There is an offense in the Texas Penal Code for those assaults committed against victims who are generally regarded as especially vulnerable. This screencast covers the offense of injury to child, elderly, or disabled individual. First, this statute identifies who the victim of the assault must be in order to charge this offense. According to the Penal Code, a child is a person 14 or younger. An elderly individual is a person 65 or older. Finally, a disabled individual includes a person with autism, a developmental disability, intellectual disability, severe emotional disturbance, traumatic brain injury, or a person who by reason of age or physical or mental disability, defect, or injury is unable to protect themselves from harm or to provide food, shelter, or medical care for themselves. Next, for the purposes of this statute, the Penal Code defines an omission, or not doing something you were supposed to do, an offense only if there is a legal or statutory duty to act. That is, the act is defined by law, or if the actor has assumed care, custody, or control of the victim. So in other words, people such as teachers or healthcare workers in a nursing home may commit an offense by omission by not doing something they were supposed to do if that something is defined by law or if they have assumed care, custody, or control of the child or elderly person. Finally, for the purposes of this statute, the Penal Code defines abandonment as leaving a child in any place without providing reasonable and necessary care and under circumstances in which no reasonable adult would leave a child of that age and ability. The key word here is reasonable. First, the Penal Code states this offense is committed when a person with any of the four culpable mental states by act or intentionally, knowingly, or recklessly by omission causes a child 14 or younger, an elderly individual older than 65, or a disabled person serious bodily injury, serious mental deficiency, impairment, or injury, or bodily injury. Second, this offense is committed when an owner, operator, or employee of a group home, nursing facility, intermediate care facility for intellectual disabilities, or other institutional care facility with any of the four culpable mental states by omission causes a child, elderly, or disabled person who is a resident serious bodily injury, serious mental deficiency, impairment or injury, or bodily injury. The offense levels for injury to a child, elderly, or disabled individual are a little complex and best visualized through this chart. An offense resulting in serious bodily injury or serious mental deficiency, impairment, or injury and committed with the culpable mental states of intentionally or knowingly is a felony of the first degree. Serious bodily injury or serious mental deficiency, impairment, or injury and committed with the culpable mental state of recklessly is a felony of the second degree. Bodily injury and committed with the culpable mental states intentionally or knowingly, and the victim being a disabled individual living in a center and the actor being an employee of the center requiring him or her to provide direct care for the victim is also a felony of the second degree. Finally, an offense resulting in bodily injury and committed with the culpable mental state of intentionally or knowingly is a felony of the third degree. It is a defense to prosecution if the act or omission consisted of reasonable medical care and it occurred under the direction of a doctor, or the omission was emergency medical care administered in good faith and with reasonable care by a person who is not a doctor or nurse. There are several affirmative defenses laid out in this Penal Code statute. First, it is an affirmative defense if the act or omission was based on a recognized religious practice of healing. Next, it's also an affirmative defense if the actor was not aware of the incident or injury. It is also an affirmative defense if the actor was a child and no more than 3 years older than the victim, who was either disabled or non-disabled at the time, or the actor could not have reasonably known the victim was disabled at the time, or the actor was a victim of family violence committed by another also charged with this offense and did not cause injury, and did not reasonably believe their actions would prevent the other from committing the offense, or the actor notified the victim in person if reasonable, the parents or guardians in writing, or the Department of Family and Protective Services in writing that he or she would no longer provide the applicable care.